Good evening, and welcome to the Marian Miner Cook Athenaeum. My name is Xuan Yo, and I'm one of the 2 Athenaeum Fellows this year. The debate over the limits of executive power is one with deep historical roots. During the period of royal absolutism, English monarchs asserted a right to dispense with parliamentary statutes they disliked. The use of this prerogative by King James II was one of the key grievances that led to the Glorious Revolution of 1688. Thus, the very first provision of the English Bill of Rights of 1689, the most important precursor to the US Constitution, declared that the pretended power of suspending of laws or the execution of laws by regal authority without consent of Parliament is illegal. To make sure that American presidents could not resurrect and exercise a similar prerogative, the framers of the Constitution made the faithful enforcement of the law a constitutional duty, a duty that some legal scholars argue that President Obama has failed to fulfill. Debates have arisen time and again throughout Obama's presidency as to whether he has pushed executive power beyond constitutional and customary limits on issues ranging from healthcare to immigration. Our speaker tonight believes that we have drifted towards an understanding of executive power today that none of the original framers of the Constitution imagined, and will argue that it is time for us to think about the limits of executive power, if indeed there are any. Professor Michael William McConnell, as the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford Law School and Senior Fellow at the Hoover Institution. He is a leading authority on freedom of speech and religion, the relation of individual rights to government structure, originalism, and various other aspects of constitutional history and constitutional law. He's the author of numerous articles and co-author of 2 casebooks, The Constitution of the United States and Religion and the Constitution. He was also the co-editor of the book, Christian Perspectives on Legal Thought. Since 1996, he has been a fellow of the American Academy of Arts and Sciences. Professor McConnell brings wide practical experience to bear on his teaching and scholarship. Before joining Stanford in 2009, he served as a circuit judge on the U.S. Court of Appeals for the 10th Circuit. McConnell was Assistant General Counsel at the Office of Management and Budget and Assistant to the Solicitor General in the Department of Justice under President Ronald Reagan, and a member of the President's Intelligence Oversight Board from 1988 to 1990. He served as chief clerk. He served as law clerk to then Chief Judge J. Skelly Wright of the U.S. Court of Appeals for the District of Columbia Circuit, and to Justice William J. Brennan Jr. of the U.S. Supreme Court. He's a graduate of Michigan State University and the University of Chicago Law School. This evening's Athenaeum talk is the inaugural lecture of the Charles Lofgren Program in Constitutionalism through the Salvatore Center at Claremont McKenna College. I must remind you, as always, that audio and visual recording is strictly prohibited. Please join me in welcoming Professor McConnell to the Athenaeum.
Well, thank you, Xuan, for that very comprehensive introduction. I'd almost forgotten half that. Before I begin, I'd like to say a word about the occasion. This is the inaugural lecture in the Charles Lofgren series. I actually forget the exact name, but in honor of Professor Lofgren, who is sitting at the table right here. And I am so touched at having been asked to do this. I can remember, I'm not sure I can remember when I first read his work, but I can tell you it was a very long time ago, long before I ever had the pleasure of meeting him, and certainly long before I had any inkling that I might be asked to give the inaugural lecture in his honor. I don't know how well known he is around these parts, but he is one of the great figures in constitutional history and constitutional law. And his work is especially important in a couple of areas. Segregation, his work on Plessy versus Ferguson, but perhaps more so executive power, and especially power related to the war power. And something I really admire about his work is the way in which he avoids what I think are 2 very common pitfalls about historical work connected to constitutional law. On the one hand, there are the historians who say, I just live in the 18th century, I don't have anything, and refuse almost as a matter of principle to apply their learning to today. And then there are those who distort their analysis of history in the service of a current agenda. And what I love about Professor Lofgren's work is that he avoids that he tells the history straight and true, but he does not hesitate to help us understand why it matters for today. And so, in honor of Professor Lofgren, I decided to talk about the executive, which is one of his great fields, and I'm going to try to connect history to the present in a way that Charles Lofgren teaches us to do. As you probably know, the title of my lecture tonight is Our 17th Century Executive. Now, this may seem like an odd title, and so let me give a brief explanation of what I mean before I get into the substance of my remarks. The big difference between the 17th century executive and the 18th century executive is this, that the Stuart kings of the 17th century, before the Glorious Revolution that Schwen has already mentioned to you tonight, before the Glorious Revolution of 1688, they exercised extensive prerogative powers. Now, prerogative is a fancy word. We don't use it very much anymore. It means powers exercised by the executive not pursuant to a statute passed by the legislative branch, but based entirely upon the independent unilateral authority of the executive itself. Now, this extensive prerogative ended with the Glorious Revolution and the Bill of Rights of 1689 that Schwen also referred to. And this ushered in the 18th century executive, which is the one that our framers were familiar with, a time of parliamentary supremacy, not monarchical supremacy. Now, but the 17th century executive asserted a number of prerogative powers. Among them, some of the most important were the power to make laws and create new offenses by royal proclamation. Royal proclamation is what we would today call executive order. The power to dispense with laws passed by Parliament, that is, to refuse to enforce laws that have been passed. The power to impose taxes without parliamentary authority. The power to borrow money to finance wars and other national expenditures. The power to raise armies on royal authority, to take the nation into war, and to make peace with other nations, all on his own authority, and to imprison people without trial. Now, even in the face of these very substantial prerogative powers, this didn't mean Parliament was powerless, but Parliament was primarily reactive. The function of Parliament in this constitutional system was to check royal abuses, but not really to exercise affirmative power in the sense of being in charge of national policy. The most important parliamentary powers were the power of the purse, so the Parliament could cut off funds to the king and thereby prevent him from carrying on projects that they considered improper. And the other was that they could hold his ministers accountable. The king could do no wrong, but, his ministers often were quite questionable, and they could be held accountable by Parliament in the form of impeachments and bills of attainder. But nonetheless, there is no doubt that in the 17th century executive, the king was the chief power in the realm. The Glorious Revolution changed all that and ushered in the period of parliamentary supremacy, an arrangement that Montesquieu famously called a republic in the guise of a monarchy. After the Glorious Revolution, and especially under the Hanoverian kings, the Georges I, II, and III, the executive no longer could make law on his own say-so. The king was stripped of his power to imprison people without trial. This was the subject of the Habeas Corpus Act of 1679. Any power to impose taxes without parliamentary approval was taken away. And the very first two provisions, as Schwen said in his introduction, the very first two provisions of the Bill of Rights of 1689 eliminated the executive's power to dispense with the enforcement of laws passed by Parliament. But the king retained a great deal of power, especially in the realm of war and foreign affairs. The king had power both to declare war and to conduct war. Now I'm talking about the 18th century executive, the king as the monarchy as it existed at the time of American independence. And the king also had power to reach agreements with other nations, even unpopular ones, and frequently did. And his powers of appointment were vast. He could create offices and attach salaries, often munificent, and thereby control Parliament most of the time by strategic grants of lucrative offices and benefits. He essentially was able to buy off Parliament. So Parliament was supreme, but the king had some very significant ability to control affairs. Now, all of this is background. Familiar background to the 54 men who met in Philadelphia in the summer of 1787, but not particularly familiar to us today, which is one reason why I think we have so much difficulty understanding the Constitution that they wrote for us. And I hope that you're not thinking that these are just matters of ancient history. If you've been listening carefully for the last few minutes, and if you've been reading the newspapers, you will realize that almost every one of the issues that I have mentioned so far has arisen again under the administrations of George W. Bush and Barack Obama. That is why I call this lecture Our 17th Century Executive. Our 17th Century Executive. Now, the executive under our Constitution as it is written, the Constitution of 1788, is not clearly drawn, and it's difficult to understand, especially with respect to the executive power. In marked contrast to the long list of powers vested in the legislative branch with detailed provisions about how those powers will be exercised, Article 2, which is the executive power article, is short, it's vague, and it is extremely difficult to understand the organization. If you try to figure out why things are where they are, it's really extremely puzzling. In particular, the powers granted to the executive in Article 2, Sections 2 and 3 seem incomplete and disorganized. Seemingly trivial powers are listed, and some extremely important powers that would naturally seem to belong to the president are left out. Why might this be? Why is it that Article 2 is written in this peculiar and unsatisfying fashion? Well, there is one sort of trivial or interesting but trivial explanation, which is that James Madison, who was the prime mover behind the first draft of the Constitution, the Virginia Plan, had no experience of an effective executive. And he had little instinct for it. He was a terrible president when he was president. And he confessed to Washington in a letter just before he embarked on the journey to Philadelphia that he had scarcely ventured an opinion about how the executive should be constituted or of the powers with which it should be clothed. That's a quote. And so, given that our, greatest mind behind the Constitution had really not given much thought to the executive, well, in a sense, it's no wonder that the clause is as confused and limited as it is. immediate backdrop here is that the Articles of Confederation, which was the initial government after independence, had no executive at all. All it had was a Congress. Congress did it all. It executed through committees. So there's a committee on foreign affairs, and there's a committee of finance and so forth. Any of you who may have ever served on a committee will, I'm sure, recognize why it is that the Articles of Confederation government relying on committees didn't work very well. Then along comes the Virginia Plan, largely authored by Madison, is presented at the Constitutional Convention, and the executive provisions of that plan are quite sketchy. In terms of its powers, the executive is given two powers. It's given the, quote, general authority to execute the national laws, and it is given the, quote, executive rights vested in Congress under the Articles. That's all it says. Now, this presupposes that we can tell which of Congress's powers under the article were executive in nature. No mean feat. And it turns out very quickly in the debates in Philadelphia this formulation had sweeping implications because the idea of executive powers had been shaped under monarchy. And so if the president is going to have all of the executive powers of the national government, that could be a little scary. And in particular, what about the powers of war and peace? Those were the prerogative powers that survived into the 18th century executive in their strongest possible form. And this led to what I think is the most dramatic moment at the convention in Philadelphia in that summer, June 1st. The Virginia Plan had just been presented 2 days before. There was a little bit of discussion of various issues. And on June 1st, they read the executive plank of the Virginia plan. And I've already told you what the powers are. And first thing that happens, Charles Pinckney, a brilliant and vain and ambitious young man from South Carolina, pops up. And he says, this is the very first thing that is said about the executive. He says that he's for a vigorous executive, but he was afraid the executive power of the existing Congress, and remember, all the executive powers of the existing Congress are going to be given to the new executive. Afraid that they might extend to peace and war. Now remember, even in the 18th century, the king retained his prerogative powers to start wars and to make peace on his own say-so. And so this is what Pinckney is thinking about. And so Pinckney then says that this would render the executive an elective monarchy, which he says is the worst possible kind, an elective monarchy. James Wilson then moves, he just makes it worse. He moves to vest the executive power in a single person. So not only does the executive have these powers, war and peace particularly, but it's all going to be in one person. And then this is the point I think is so dramatic, because Madison records in his notes, he says, a considerable pause ensuing. It's the only time in the entire report of the proceedings at Philadelphia that Madison mentions that there was a pause. Usually people are popping up, happy to get another word in. It's a pause. They're sitting there silent, and why doesn't anybody say anything? Well, this is a momentous question that they're looking at. Are they going to create an executive that is effectively an elective monarchy? And then there's a second reason, I think maybe more important, which is for why nobody was willing to say anything, and that's George Washington is sitting there. And everybody knows that George Washington is going to be elected the first president of the United States. So anything you might say about the dangers of tyranny are going to appear to be a commentary on General Washington, for whom everyone had enormous affection and respect. And so how can we talk about this thing with him in the room? And so after the pause, it's interesting. So Benjamin Franklin, who is the oldest member of the convention and the only person in the room who has a genuinely global reputation that is, approaches that of General Washington, coaxes them to speak. John Rutledge, notoriously the most effective executive of any state during the Revolution, does the same, and then they begin to talk. James Wilson says, well, he's saying maybe Pinckney isn't right. He says the only strictly executive powers are appointing officers and executing the laws. Not much danger there. And Madison then says, well, actually, how about this? Let's say that the executive will be able to execute the laws and appoint officers, Wilson's minimum, and also to be able to carry out any duties assigned to him by Congress that are, I think this is so amusing, not legislative or judicial in nature. The way he puts that is so revealing, because they don't know what's executive in nature, but they have a pretty clear idea about the other branches. And so all that Madison says, if we exclude things that are legislative and judicial, everything that's left, where Congress can assign to the president. And then it's over, and the convention does not return to defining the powers of the presidency until August. And even then, most of the work and the discussion takes place in the Committee of Detail, so we don't know what was said. We have a lamentable lack of knowledge about what went into the actual formation of the executive. But the basic structure is this, and this is not so much from historical records as it is just from the text of the Constitution. The basic structure is this, that the first sentence of Article 2 vests quote, the executive power, whatever that means, in a president of the United States. And then the Constitution transfers many of the most controversial and important powers that had been exercised by the king to Congress. And in addition to that, explicitly limits a number of the executive's powers by making them subject to advice and consent or other limitations. So, let me just read you the first sentence of Article 1, which is the legislative article, and Article 2, which is the executive article. Article 1 begins, all legislative powers herein granted shall be vested in a Congress of the United States. Article 2 begins, the executive power shall be vested in a president of the United States. So note how different those provisions are structurally. So Article 1 vests in Congress only those powers herein granted, which is to say those that are expressly listed. Article 2 does the opposite. It gives the executive power all to the president, except when elements of the executive power have been assigned elsewhere or forbidden to the president. The most interesting of the executive powers that is denied to the president is the power to make war, to initiate warfare. A power vested in the king in the 18th century Constitution of Britain. The Committee of Detail gave Congress, not the president, the power to, quote, make war, to make war. On motion by Madison, This was amended on the floor to read, to declare war, and that's the language of our Constitution. So they changed make war to declare war. What does this do? This has produced, I don't know how many articles, of which Professor Lofgren's are among the best. But I think there are two things that are fairly clear from this. One is that they were fearful that the idea of making war would include conducting war, and they didn't want Congress to be conducting the war. They wanted an executive to conduct the war. And the second thing is that they're worried about defense. That what happens if there is a sudden attack? You'd have to go to if the only power is to make war, well, Congress has to respond to the attack, and that's not very practical. So let's use the word declare war, which means something like to initiate war, to start a war. Whether that actually means by formal declaration, questionable. Hamilton in the Federalist says that declamations of war have passed into disuse. Sir Robert Walpole, the prime minister for 40 years under the 18th century Constitution, said that most wars are declared out of the mouths of cannons. But the power to declare war is vested in Congress, and essentially that means the power to start the war. We could go into much more detail about nuances here, but the important point being that this prerogative power of the king of starting wars was not vested in the executive. But this power is not the only one that was vested in the king that was given to Congress. The king also had the power to enter into agreements with other nations without Parliament, and under the Constitution, the executive negotiates the treaty, but it requires a 2/3 vote of the Senate to actually go into effect. That's a really strong limitation, right? They did not want this country to become obligated under international agreements without not just a majority, but actually 2/3 vote of the Senate. In addition to that, Congress was given the exclusive power, and this is a little bit more like the Glorious Revolution, exclusive power to borrow money, to tax, to spend money. And by the way, for spending, there's a double-barreled protection. Not only is Congress said to have the power to spend, but Article 1, Section 9, Clause 7 provides no money shall be drawn from the Treasury, but in consequence of appropriations made by law. So it's a double barrel. Congress can spend and nobody else can spend money in the Treasury, and that means not the president. Congress is also given the power to regulate private behavior and punish violations. Again, this is a double-barreled protection. Not only is Congress given the power to make law within the scope of its enumerated powers, but the Due Process Clause denies the executive the power to punish in the absence of law. So we could not have common law crimes. The Supreme Court holds that in 1812. And we could not have crimes created by proclamation as under the Stuart kings. In addition to this, the power to execute the law was phrased as a duty rather than a power. The president shall take care that the laws be faithfully executed. Not that he has the power to execute the laws, he shall execute the laws, or at least he shall take care that the laws be faithfully executed. I think the language there does suggest a degree of discretion about how, because I think they understood not every law can be enforced 100% of the time, but faithful execution is what the president is required to do. And these provisions, as Schwinn actually, stole so much of my thunder in the introduction, but as he points out, these provisions were designed to carry into effect the first two provisions of the English Bill of Rights, which forbade the king to any power to dispense or suspend laws. In addition to this, there are prerogative powers of the president, powers that he executes on his own say-so, and Congress can't do anything about it, but they are enumerated and defined. It's the power of veto, the power of pardon, the power of command of the Army and Navy, the power to negotiate, although not to finalize treaties, perhaps other foreign affairs powers, this is a little bit dubious, power to appoint officers to offices created by Congress subject to advice and consent. Undoubtedly, the framers regarded Congress, not the president, as the most important and, by the way, most dangerous of the branches of government. Madison wrote in Federalist 48, he said, "The legislative department is everywhere extending the sphere of its activity and drawing all power into its imperious vortex." Right. The president was understood to check this enormous power of Congress, not the other way around. So how is this working out? Now, I'm going to give some examples of very recent events. And before I do that, let me give a warning. All of these examples are current, meaning that all of these examples involve President Barack Obama. And a lot of the examples involve policies that many of us support. But not every president is Barack Obama. If I had been giving this lecture 7 years ago, my examples would have involved his predecessor. If I were giving this lecture 7 years hence, these examples would involve his successor. This is not about President Obama. In recent decades, each president has pushed the envelope of executive power more than the one before. And I don't usually predict the future. It's one of the hardest things in the world to predict. But I will predict that whoever is President Obama's successor will push the envelope of executive power even more. It's the nature of the beast. So let's try to put Barack Obama out of our minds. If you're a Republican, imagine we're talking about the powers of President Hillary Clinton or Bernie Sanders. If you're a Democrat, in fact, even if you're a Republican, I suggest you think about what President Trump might do. It's very healthy when thinking about the powers of government to imagine your worst nightmare driving the boat. So start with the powers of war and peace, which so concerned Charles Pinckney. Our presidents now can initiate war without congressional authorization or deliberation. Do you remember Libya? Not that just a couple of years ago. We were not attacked. We spent over a month bombing targets, both military and civilian. We did not stop until we had deposed Muammar Gaddafi at a cost of billions of dollars and thousands of lives. Not American lives, to be sure, but lives. The administration was not willing to start the war without authorization by the United States Security Council, spent months negotiating that, but he did not seek and he did not receive authorization from the body Congress, which the Constitution seems to say has authority to decide whether to start a war. And to its shame, the Department of Justice Office of Legal Counsel delivered up a written legal opinion that the war clause was not violated by this action. I recommend that you go on the internet and pull up this legal opinion. It's easily available. Read it and see for yourself how persuasive it is. Now, how about treaties? Just in the last few months, we have seen a very important international agreement with the Islamic Republic of Iran. Some people are for it, some are against. Lots of members of Congress have grave misgivings about the wisdom of this agreement. But did it require a 2/3 vote from the Senate? It did not. It was put before Congress, and it was going to be approved so long as there was not a veto-proof majority to disapprove. And in fact, as soon as 40 Democratic senators had stated, they hadn't even voted, they just stated to the press that they were not going to disapprove this, it was all over and there was no further debate, 40 being the magic number to filibuster. Right, and so we have an international agreement that the president makes on his own, and it goes into effect unless a supermajority of both houses is willing to disapprove of it. How about lawmaking? Well, here the list is enormous, and certainly this does not. Some of these other examples do seem to be Obama-specific, but this does not. This goes back a long time. That there are many of the most important legal regimes under which we live were not enacted by the Congress of the United States, but by the executive. Just a few examples. Net neutrality from a few months ago. Executive proclamation claiming authority under a Telecommunications Act that was passed before the internet was even invented. On college campuses, this is an important regulation of sexual conduct of students on campus, regulated through a so-called Dear Colleague letter issued by the Civil Rights Office of the Department of Education with hardly any legal authority, and yet it has changed the way in which everyone's life is lived on campus, for better and worse. Climate change, even the Democratic Congress elected in 2008 was unwilling to pass the president's proposed climate change legislation. Now it's being imposed through regulation. The minimum wage has been increased through an executive order directed at contractors. Just yesterday, the newspaper yesterday reports that the White House is planning gun control through executive action and not through congressional legislation. Now, maybe some or all of these are good ideas, but it's hard to escape the conclusion that in our system today, it is the president who makes laws, not Congress. But law execution, there's so many examples now of the executive announcing that it is not going to enforce a law. Even laws like the Affordable Care Act, which were the administration's own laws, portions of it are either delayed or not enforced. The most conspicuous example of this being in the immigration field, where the administration proposes and Congress debates the DREAM Act, does not pass it, and then after stating over 18 times publicly that he did not have the authority unilaterally to dispense with the enforcement of the immigration laws in these circumstances, the president announced that in fact he does, and some 4 million people who under the statutes of the United States, again for better or worse, are not lawfully present and not entitled to work are given work permits, Social Security eligibility, earned income tax credit eligibility, and driver's licenses. This action is being challenged in a case called Texas against United States, now before the Fifth Circuit. I think this is one of the most important pieces of litigation in the country today, more important than any of the cases now before the United States Supreme Court. We should watch it. Appropriations, I had thought, this is sacrosanct, the power of the purse. Surely the executive will not spend money that has not been appropriated by Congress. But the administration requested funding for certain subsidies to insurance companies in connection with the Affordable Care Act. Congress did not appropriate that money. The administration went ahead and spent it anyway. This is now under challenge in a case called House of Representatives versus Burwell. This is particularly interesting. It was just the initial decision was just, I think, 2 weeks ago from the district court. The administration is arguing that no one has standing to sue which means no one could prevent the president from spending whatever he wants, whether there's been an appropriation or not. The administration's lawyers argued that Congress has the ability to defend itself without need to go to court because, and it pointed specifically to Congress's ability to withhold appropriations when it doesn't approve of what the executive has done. The district court pointed out that this was an ironic argument since the whole point of the lawsuit was that Congress had withheld funding and the administration had spent it anyway. There may be some question as to whether this appropriation was made or not. I'm inclined to think not, but that's a legal question. The most important question is actually the one of standing. That is there anywhere in our government that we are able to enforce the rule that the executive cannot spend money from the Treasury without an appropriation? Because if there is no standing, then there is no limitation. If there is no limitation, I think we have now learned that there is not self-restraint, and the next president is not going to show any more self-restraint than this president has done. Now, these examples, to my mind, look more like the actions of a 17th century executive than those of the president described in Article 2. Makes me wonder what happened. I just realize the night is getting long. I'm going to go through this as quickly as I can, but I think there's certain misconceptions that the framers had about the way that their Constitution was going to work. I think there are 3, maybe 4 of these that are most important. The first is that they did not anticipate the rise of political parties, and especially of the degree of political partisanship that we now are experiencing. They did not imagine, what they thought is that the ambitions of individual office holders in Congress would be wedded to their position, and thus out of their own self-interest they would jealously guard the powers of Congress. They did not imagine that members of Congress would be more loyal to a president of their own political party than they are to the institutional prerogatives of the body. And I do not refer here just to one party. Both parties are equally guilty of this if it's a problem. But this means that the congressional checks to presidential action are almost non-existent, because all it takes to prevent a president from, what it takes to prevent a president from carrying an improper or unauthorized action is all it takes is 1/3 of either house of Congress, because otherwise the president will be able to veto any legislation they pass that may be designed to check their authority. So as long as a president retains the loyalty of 1/3 of one branch of Congress, Congress is not going to be able to do anything. I think of Richard Nixon in Watergate, who was brought down only because the Republican Party lost faith in him, but had 1/3 of one of the branches of Congress maintain loyalty to him, he would have served out his second term. The second thing is that the founders assumed that congressional inaction, which is the product of the extended sphere and the checks and balances, would enhance liberty and control faction. So the idea is extend the sphere, we have lots and lots of factions, and then you have checks and balances. This is the theory of Federalist 10 and 51. I assume most people here are familiar with those arguments. And it, according to Madison, under this system, legislative action could seldom take place on any other principles than those of justice and the general good, which I think is actually pretty true, because legislative action can seldom take place anyway. This is really an argument for gridlock, it's not an argument. It doesn't actually separate out good from bad action in any important way. But if you want Congress to check the executive, Congress has to be able to act. And if the factions and the checks and balances paralyze Congress from acting, Well, the executive is going to be able to move into that vacuum and exercise power that perhaps it wasn't intended to have. Just look at what happens when members of Congress today try to use the power of the purse to restrict executive action. Ted Cruz, for example, they end up threatening, what are they going to do? They're going to hold up the appropriation. The president's going to veto it if it doesn't get passed, and then it's going to be a government shutdown, and it effectively means that the power of the purse is a paper tiger. Third thing is that the founders did not anticipate the wholesale delegation of regulatory power to executive agencies, or that courts would defer to executive interpretations of vague laws. The way in which the Congress legislates today is very rarely do they pass an actual law, that is something that tells somebody that they can or can't do something. Right? What they do is they delegate power to make regulations to the executive branch, and then the executive branch is able to run with it. This has become an end run around the idea that the power to make laws is vested in Congress, not the executive. And then finally, maybe least important, but nonetheless important, they didn't imagine that there was going to be a filibuster. This was a development that took place about a century after the Constitution. And what this means is that nothing can pass Congress without a 60%, a 60-vote majority in the Senate, which is very difficult to get. This is like saying we don't want a Congress that is able to exercise power. Now, we're all happy to have the filibuster when things are going on that we don't like, right? But this means a government in which the Congress is not going to exercise the kind of primary role that Madison had in mind. Somebody's going to exercise that role, and the somebody is the person living at 1600 Pennsylvania Avenue. Please note that most of these developments have not been the fault of overreaching executives only. I haven't even mentioned grasping executives, right? They just respond to the vacuum that is left. The problem is the void that Congress has left because of Congress's own inability to exercise the powers that have been delegated to it. So, Democrats bemoan the imperial presidency when a Republican is president. When the president is a Democrat, they're okay with it. And it's the Republicans' turn to complain, right? But as John Locke warned in his second treatise of government, the precedents established today will be the excuse for more overreach tomorrow in the service of other ends. He tells us that a good prince is the most dangerous to the liberties of the people, because when he acts, the acts will be popular. That will then establish the precedent, which will then be abused down the line. Now, in my opinion, Charles Pinckney was right to be concerned about an elective monarchy, no matter which political party that elective monarch may belong to. Thank you. So I gather there's now an occasion for questions.
Yes, we do now have time for questions. If you have a question, please raise your hand, and Henrietta or myself will come to you with a microphone. As always, priority will go to students.
If the president is supposed to go to Congress in terms of ratifying treaties, is there any sort of historical precedent for what the executive branch is supposed to do when you're talking about like multi-country sort of cooperation, things like the UN or like the Trans-Pacific Partnership that was just passed? Not like two-country treaties, but sort of broader coalition acts. How does that fit in with the executive power?
Treaties among multiple nations have been with us from the beginning. Actually, the peace that ended the American Revolution was not just a bilateral treaty between the United States and Great Britain, but included France and Spain as well. And the Pacific Trade Agreement that you refer to is going to be passed, is going to be voted upon by the Congress. So I mean, I can see how it presents, logistical difficulties, but I don't think there's any legal difference between a multilateral treaty and a bilateral treaty.
Hi, thank you for coming and talking to us tonight. So you started to imply there at the end of your talk that a big part of the reason why this transfer of power to the executive has happened is because Congress has essentially chosen, for various reasons, not to exercise the authority that the Constitution gives it. And then the president, someone is going to step in to fill the void, and that's going to be the president. But it seems to me that even if the Congress doesn't exercise these powers, wouldn't it be the role of a responsible president to say, that's on the Congress to do, that's their prerogative, it's not my place to step in here, so shouldn't the blame be placed at the feet of the president anyway?
I mean, fair enough. I do think that we rely to a considerable extent on the self-restraint of the executive. So I used to be an executive branch lawyer, and one of the most important jobs of the Department of Justice, and especially the Office of Legal Counsel, is to say no. And I don't think that that happens with the frequency that it used to. I would have said that if you have people appointed to positions in the Department of Justice who have substantial reputations, such that they will be ashamed to go back to their friends and colleagues having done something untoward, they will be hesitant to put their name to a legal opinion which can't hold up. Dare I say the name of my friend John Yoo, a professor at University of California Law School, whose name is on the legal opinion approving some of the extreme interrogation methods, right? But that opinion is no less disgraceful as a matter of law. Maybe morality, maybe different, orders of magnitude, but it's there have been other opinions that are just as weak. I do recommend that you read the opinion justifying our intervention in the civil war in Libya if you want to see an example of an opinion that I think the lawyer should have been ashamed to sign. There have been a couple of institutional developments too, which I want to publicly bemoan, which is the growth of the importance of the Office of White House Counsel is part of the story here. The White House Counsel was created to be the personal lawyer for the president, and I don't mean personal in the sense that they do his taxes, but I mean that they represent the president personally in his official capacity. They are not lawyers for the people of the United States. The Attorney General is the lawyer for the people of the United States, and I have to say this was even worse under the George W. Bush administration, but to a large extent carried forward. The White House Counsel is treated as if that is an alternative source of legal opinion for the president. And so in the second phase of the Libya matter, after the Department of Justice approved the constitutionality of the action, the next question was, well, how about its legality under the War Powers Resolution? And the War Powers Resolution does not use the word war, but uses the word hostilities. Congress deliberately adopted the word hostilities to include anything, right? And thus avoiding, so there may be a gap between something that's a full-on war versus hostilities. And the president asked the Office of Legal Counsel for an opinion that the Libya affair did not fall within the War Powers Resolution. To their credit, the Office of Legal Counsel said, no, we will not give that opinion. Now, that is not written anywhere, because when they say no, it isn't written. What did the administration do? They went to a combination of the State Department legal advisor and the White House counsel, and they advised that the War Powers Resolution was not triggered. So when the administration is able to shop around to the White House counsel, who is, after all, the president's lawyer, not the country's lawyer, this is not a good thing. And so I blame the decline in professionalism among executive branch lawyers. I think has a lot to do with what we're talking about. If they are willing to approve whatever goes on, an extremely important internal check is gone. And when I was in the executive branch, Ted Olson, whom the lawyer in the recent same-sex marriage case, was Office of Legal Counsel, and I know he said no quite frequently. I know he did that because he said no to my boss on more than one occasion. And when he said no, that isn't legal or that isn't constitutional, we didn't do it. And that's the way it ought to work. I disagreed with him sometimes, but I absolutely believe that that's what you need. And you need somebody of stature who is embarrassed to put their name on an opinion when that opinion isn't properly written.
First, I wanted to thank you for your talk, and denote that my question is probably going to be a pretty difficult one to answer because it's under significant debate right now within an academic sphere as well. But so what I understood from your talk is that
I hope you're looking at, is that a constitution in your hand?
it's my notebook, but so what I understand is that a big part of the reason that the executive is continuously starting to get more and more powerful, and that you anticipate it to continue to do so, is the fact that, as Michael mentioned, that Congress's inability to act or polarization is creating a vacuum which the executive then fills. Going forward, is there a way you see to reverse the process?
Well, it's hard because I think the partisan polarization is dwarfing sensibilities about good government, not just in Congress, but among lots of our fellow citizens. And that makes it very difficult because the short-term partisan or policy, sometimes it's not partisan, sometimes it's policy considerations, seem to dwarf long-term institutional considerations. But I do have a modest suggestion. My favorite proposed constitutional amendment, and this will label me as law nerd of the year, is to amend Article 1 to provide that the rules under the Constitution now, each House of Congress is entitled to write its own rules of procedure. So my proposed amendment is to change that and say that Congress shall write rules of procedure that will go into effect X years from now. I don't know quite what X would be, 3 years, 5 years, far enough in the future that we don't know which party is going to be in power, we don't know who the president is going to be, we don't know, and so we won't be able to predict who benefits from the rule. It will be what John Rawls would have called behind a veil of ignorance, right? And maybe, I think this would force Congress to ask itself the question, what kind of rules of procedure make sense? And I don't actually think that requiring 60 votes for everything to pass the Senate makes any sense. Maybe something to delay hasty legislation. Maybe a minority should be able to slow things down, but to block anything to the point that the business just shuts down if you can't get more than 40 votes, I don't think that would make sense to anyone. I think that if Congress is going to assert a power to subpoena administration officials, that it needs to have that power. And it is, I just think, unfathomable that this administration has flouted subpoenas from Congress, and then, of course, the Attorney General doesn't prosecute, right? And Congress does nothing about it. Why do they do nothing about it? Because those aligned politically with the president don't want them to do anything about it. So I say maybe in the future, if we thought about an abstract president without knowing who it is, and an abstract Congress without knowing who they are, maybe they'd be able to write some rules that would make Congress a less dysfunctional institution. So Ralph.
You have served on an appellate court. You have, in the past 2 years, argued 2 cases before the Supreme Court. A number of students here tonight are in classes where we're going to be reading your work in Florida against Department of Agriculture, the Raising Marketing Orders case. What's it like to prepare to argue before the Supreme Court? What's it like to stand before the court having said, Mr. Chief Justice, and may it please the court? What's it like once that process gets going?
Well, it's actually great fun. And I never had more fun than in the Raisin argument. This was exactly 1 week before the same-sex marriage argument, and they were bracing themselves for some very contentious times, and they were in the mood to kind of enjoy my argument, which was quite nice. How do you prepare? You need to think through everything in your case more thoroughly than you ever did when you were writing the brief, and more thoroughly than they do. You need to know every case. You need to. A very important part of preparation is to have moot courts in which people pepper you with questions. Horn, the Raisin case, actually went to the Supreme Court twice. The first time it went up, the lower court had held that there was no jurisdiction to consider their takings clause claim. That was actually a harder case on the merits. And the first moot court that I did, I thought I knew my case pretty well. At the end of the moot court, I was bludgeoned. I was a bloody mass on the floor that I just, put me out of my misery, get the mop. And it made me think much harder about my position than I had been forced to think before, because these questions were much harder than anything that the opposing lawyers had put forward. And I did 2 more moot courts. Each one was a little bit less brutal than the one before, and I won that case unanimously. So the preparation of having people just be as merciless as possible in asking me questions, that's an important part. And you need to know so this particular, the last case, I was about 2 minutes into my argument when Justice Sotomayor, who kind of likes to do this, asked me, well, what about Leonard versus Earl? Well, Leonard versus Earl is a 1932 Supreme Court case that had been cited once by the government on the other side of this case, once by the government for a completely innocuous proposition. They hadn't made any arguments based upon Leonard versus Earl. It was just a throwaway citation. And I think Justice Sotomayor was asking this not really because she wanted an answer. I think she was trying to show that McConnell wasn't properly prepared, and that this would be a feather in her cap or something like that. I felt, fortunately, I knew Leonard versus Earl as I knew every case that had been cited on either side of the of the case, and I was able to describe the case. And the case is, by the way, about the raisin case is about whether the government can take large portions of raisin farmers' crop without paying for it. The Leonard versus Earl is about Maryland taking 10% of oystermen's oyster shells without paying for them. So, you know, their cases are at least somewhat similar, except that under the common law, oysters belong to the state. And so they license the oystermen to harvest the oysters, but the oystermen don't actually own the oysters on the bed of Chesapeake Bay. And so if the state wants to say you can harvest the oysters so long as you give us 10% of the shells, you know, no problem with that. And so this is the way I answered it. And I got two or three. I mean, once Leonard versus Earl was on the table, you know, there were 3 or 4 different questions about it. And I ended by saying, unlike oysters, raisins are not wild animals, even if they're dancing. And usually it's bad practice to make a joke, because they're supposed to make the jokes and you're supposed to laugh. But if I hadn't happened to, you know Leonard versus Earl, I would have looked like an idiot, which I don't like to do. Yes.
Can I ask first? Just kidding.
Harvard, the 28 Harvard law professors collectively protested your colleague's letter as being outside the authority of Title IX and giving short shrift to civil liberties on campus. I wonder to what extent that's common in law schools, and to what extent, what's good about it, what's bad about it, from your perspective, for law schools, a bunch of professors getting together and protesting something that they don't think is right. And I'm curious as to why it's at Harvard and not at other law schools.
Well, it's not unusual for law professors to pop off on various public issues. Law professors think that we law professors think we're experts on everything, and so we're not shy about getting together and signing joint statements. What was unusual about this particular letter is that it was signed by some of the leading feminist law professors in the country against a measure which is widely regarded as a pro-feminist measure on grounds of illegality and unfairness, which is to say that the signatories of this letter were saying essentially that our side is overreaching, and without arguing whether it's right or wrong, I happen to agree with the letter, but that's aside the point. I greatly admire that. It is easy to complain about what the other side does, right? And nobody really much pays attention to that. What really is unusual and is effective is when we police the overreaching on our own side. And I like to think that I would sign a similar letter for something that, you know, where my political allies were responsible, because I just so admire what they did. Now, why only Harvard? My question is, you know, why Harvard? It's just such an unusual thing for people to do. My colleagues at Stanford didn't do it.
This will be our last question for the night.
So during your talk, you talked considerably about Congress's inability to function as a check on the executive. And there's the third branch of government, which is the judiciary. And I want to know what your thoughts on whether the judiciary could function as an effective check on the executive. And I asked the question with Truman's reaction to the steel seizure cases in mind, and whether you maybe think that's the high watermark and that we're on a decline from there.
Excellent question. I began my con law class with the steel seizure case because I do think it's quite central. The judiciary is better constituted as a check on the executive than in some ways the Congress is. I was talking about the reasons why Congress doesn't work very well. The interesting, if you think about the judiciary as a political institution, I'm not saying it is just a political institution, but it is at least partly a political institution, and we should think about how it is constituted. The way it is constituted is that it represents past presidents also. And so if you look at the United States Supreme Court, we have, two justices who were appointed by President Reagan. We have one that was appointed by the first President Bush. We have two that were appointed by Jimmy Carter. We have two that were appointed by George W. Bush. We have two that were appointed by Barack Obama. It is like a layer cake of American politics going back. And so, and the lower courts, which are very important for these things, at the end of 8 years, a president typically names 40% of the lower federal court judges, which means that during most of his administration, the court is not dominated by his own appointees, but rather by appointees of past presidents. And it has been a feature of politics for my entire lifetime that the presidency switches hands every 8 years. The only exception to that was when Jimmy Carter, well, frankly, was such a bad president that he gave 4 years to the other team. But in general, every 8 years we switch, which means that the courts are in balance, and that means that the courts are not lapdogs to the administration, and so they're really better positioned in some ways as an institution, as a check. But legally, there's some problems. The courts are best positioned as a check when the executive is asserting the power to regulate and punish a private person, because that private person has both standing and the incentive to challenge it. Actually, often they don't, because businesses with a lot of interactions with government often do not want to get on the wrong side of their regulators, and so frequently they will tolerate actions that they think are illegal or unjust because it's just a cost of doing business and better than having turning their regulators into enemies. But at least in theory, this kind of action, that is when the government, when the executive asserts the power to regulate something that Congress hasn't given into its power or something of that sort. In theory, that's the easiest, and there are, in fact, lots of cases of that sort. We don't usually even view them as big constitutional cases because the nitty-gritty of them are, do the law authorize this or not? It'll be a question of statutory construction. It is much harder for the judiciary to regulate when the government does something which benefits people as opposed to regulating and punishing them. So when, for example, Congress spends money that isn't appropriated and gives it to somebody, who's harmed by that? We don't allow general taxpayers to sue. That goes back to a case in the 1920s. Who can sue? This district court held that the House of Representatives can sue. It has never happened before. This is a very important question. If the House of Representatives is able to sue in this case of spending non-appropriated funds, then there will be a check. If they can't sue, there is no check, and I confidently predict that once presidents figure out that they can spend money that wasn't appropriated and nobody can do anything about it, they will, their self-restraint will not be enormous. So that's another category of case. The immigration case almost looks like that because you have some 4 million people who are being benefited by the action. Well, who's losing out? Well, arguably there may be some people who are losing jobs and so forth, but it's too indirect and speculative and spread out to justify standing to sue. The reason Texas and the other 25 states who are plaintiffs in that case were held to have standing to sue is because they're required to issue driver's licenses to these immigrants, and that is costly. It's a trivial amount of money. It's about $60 or $80 a person in Texas. The case is not really about that, but in order to get into court, all you need is a small but concrete injury, so the states are there. But again, that's an important question as to whether they can. But there are whole areas in which it's very hard to find somebody with standing to sue. The King versus Burwell case from last term, which was the challenge to whether the executive could provide subsidies in states where the state had not itself set up an exchange. There were 4 plaintiffs in that case. Their standing was based on real happenstance. And I looked at this, I'm convinced that 3 of the 4 did not really have standing. One of them probably did, but you know, that whole case would not have happened if we didn't have this sort of weird situation in which that person was concretely injured. So standing is a very big obstacle. And then even if there are people with standing, the non-enforcement of the law is not easily dealt with by the judiciary, because if the executive doesn't want to do something, it has millions of reasons and excuses and dodges, and you know, you can almost always find yet another reason not to do it. And so the court might hold, yes, you have to enforce X law. Well, how much do you have to enforce it? How many police officers do you have to assign? What are you going to do? There was a case against Richard Nixon's administration of this sort when they decided not to enforce the law which required the cutoff of funding to racially discriminatory higher education institutions. This is Title VI of the Civil Rights Act of '64. And the D.C. Circuit held that that was wrong, that the law says they have to be cut off. What the administration said was, oh, well, we're going to enforce this, but we're going to enforce it through cooperative arrangements and trying to work with them rather than cutting off their students. And the court said, you can't do that. You have to cut them off. Well, that was just the first case. The next case was, well, you know, this excuse doesn't work, and you're not doing it quickly enough, and et cetera, et cetera. By the end of the whole process, in the 1980s, so we're now talking about 15, 16, 17 years later, the district court was controlling 80% of the budget of the Office of Civil Rights of the Department of Education under that decree, because once you start ordering the executive to do something, you can't make them do it without getting to more and more levels of detail. The most famous recent case was Massachusetts against EPA. The George Bush administration believed that the Clean Air Act did not authorize the regulation of carbon emissions, because carbon emissions are, they said, not a pollutant. And there are all kinds of provisions of the law which don't really make a lot of sense for carbon emissions. And the Supreme Court held that Massachusetts has standing because the seas are rising, and that'll take away part of their beach front property. And so they have standing. It's as good as driver's licenses, right? And held that the administration was wrong not to enforce this aspect of the Clean Air Act. Again, it sounds a lot like the immigration situation. But to this day, nothing yet has quite happened, even though the current administration is eager to use the authority, but it's just very hard to force the executive to actually take affirmative steps. So the judiciary is more available for some kinds of executive assertions of power than it is for others. It's most able to stop direct regulation of private people, not so able to deal with benefits given to people, and especially not so able to deal with the decision not to enforce the law. So We're now seeing, I also think there's this phenomenon that it's usually toward the end of the administration when the courts begin to take more action. So take George W. Bush and the decision to detain enemy combatants at Guantanamo. Guantanamo was specifically chosen because it appeared to not fall within the scope of habeas corpus jurisdiction, and so the president was able to do this without fear of judicial intervention. But in Rasool and Hamdi, the Supreme Court held first that the president could not indefinitely detain people without the authorization of Congress. So it wasn't really saying that you can't do this, it's saying that you can't do it on your, this could not be a prerogative decision of the president, even under his commander-in-chief power to prosecute the war. And then in Boumediene held that even Congress's action had gone too far in not respecting the limits of the Geneva Convention. When those cases first started coming, they looked like they were pretty out there. The administration had thought through this Guantanamo theory, and it took a while, but by the end, the courts were ready to start slapping them down. And I think a similar thing is happening now, that for most of this administration's history, the major actions have not particularly gone unchallenged, but I think the Texas immigration case and the House of Representatives appropriation case are serious judicial efforts, and I think it's not surprising that they're coming at the end of the administration. I think that's the way the dynamics of these things tend to work.
Please join me in thanking Professor McConnell for tonight.